That's better. We are on the stage. I have a doggy behind me that's snoozing away there, waiting for the court to underway. So they went through quite a bit of stuff yesterday, didn't they? They went through some motions. They went through some of the requests that Sarah had, and then they went through some of the requests that the defence had for removing certain pieces of evidence, photographs, that kind of thing. I mean, you got to give it, haven't you, to her attorney. He's fighting her battles for. He's trying hard, bless him. So we'll see what comes of that. But it always amazes me in these cases where they try and, remove the evidence. But I'll be honest, I think once the jurors actually see that suitcase video, yeah, I think that's going to be quite hard if they've not seen it before either. The fact that she left him in that suitcase and she was bleeding the defense thing, and that's fine, that's great, the defense thing, but the thing is, he was in the suitcase, so there was nothing he was doing to her. And then the argument is, well, she knows what he's like from his past, and she knows that he's likely to get angry, etc. But she didn't flee the house either. She just stayed in the house. Knowing or believing that he would potentially get really angry with her and come for her for zipping him up in the suitcase. And I think we're going to learn more stuff about this case as it goes, which is going to be interesting for sure. Things that we perhaps didn't know before. Things that we will need to know, get to know. And who knows, by the time we move through this process, we might actually have a difference of an opinion. Those who think that Sarah is completely innocent might think actually she isn't. And those who kind of feel, well, she did what she did, they might change their mind and think, well, actually, no, she is innocent in this. Anything is possible. So we're just waiting for court to get going. The cameras are in the courtroom. I mean, heaven forbid that they're on time. I imagine they've got Sarah in. This bit's the hardest bit, isn't it? The waiting. The waiting. I wonder if they're dealing with in-house matters and getting settled. Oh, the people in my house are so noisy. So noisy. You probably can't hear as much. Have we got any highlights that we can watch while we're waiting? I do like a highlight, don't you guys? Let's have a look. because I really don't want to sit here and bore you to death. Right, now I've... Let me just sort that out, guys. All the weird stuff was happening then. Let's just swap let's swap screens for a minute while we're waiting.
Trial not opening up just yet. They're still working on getting that jury seated. They started on Monday. They're going to continue today. They have a motions hearing set for 9:30. Apparently still some outstanding motions. And then they're going to continue picking the jury in the afternoon. And in case you didn't hear, Sarah Boone filed a motion requesting snacks at her trial. And so we're going to get the answer from the judge this morning about that. Take a listen.
Yes, sir, Mr. Owens.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning. And then, of course, she's brought up around 9. And then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart. To allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not the state attorney's office and any of the parties involved.
Okay. I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. That's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right, anything else?
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks. She's not going to the movies. She's going to her homicide trial. And she's being specific. She's going, I want, 5 peppermints. I want to have a Pop-Tart or some cookies, 2 bags of potato chips. Get real. This lady's unbelievable. What about the sadness she might feel for her boyfriend, George Torres, who lost his life? He doesn't get to eat anything. And by the way, the jail is sending over meals for her. My understanding, 2 meals to be sent over. So it's not like this woman is starving. She just must think she's special. Let's bring in our attorney guest to talk about this. Very seasoned trial attorney. He was a homicide prosecutor, Randolph Rice, on the program today. Randolph, can you believe this lady? The nerve with her.
No, I can't. And this seems to be consistent with what she's been doing since the beginning of this charges. Remember, she's been, and we've talked about this for a couple of months ago, she's gone through, 9 lawyers now? And this seems to be consistent with what she has done leading up to this point. I guarantee she had this conversation with her defense team. They probably told her, no, we're not going to ask the judge that. And she probably pushed back, and they thought, you know what? Just to cover ourselves, we're going to ask the judge, as crazy as it may be. And I guarantee you this, the defense attorney was embarrassed to ask for that request. When he turned around, he looked like the most embarrassed person in the world because he knew how silly it was. He knew how ridiculous it was, but he still has to do what his client is asking him to do. And here we are with another crazy request from Ms. Boone.
Yes, Randolph, you're so right. You said what we are all thinking, that attorney would never want to ask those questions of a judge. We never think of that. But because he's got a bossy client, he did what she probably pushed him to do. I think your analysis is spot on. Here's another clip I want to show you, Randolph, where she's probably pushing for more outfits. She's very concerned about how she looks. We know that she wanted a glam squad. She wanted a professional hair and makeup artist, to do her hair and makeup for this trial. I mean, it's incredible to me. Let's listen to what her lawyer said to the judge about that.
She expressed, it was a 2-week trial, she wanted to wear something different every day. They expressed to me that if I would just bring her her clothes every morning, whatever she wanted to wear, and then pick them up in the evening, the clothes she wore that day, that would work with them instead of going to the visitation center and that whole process. So I think that is probably the way to go.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30 today to try to figure out what the issue was with the clothing.
Is always an issue with her, Randolph, as you know. Would you speak to how things typically go when you're getting a client ready for a trial, and if they're being held in jail prior to the start of the trial? Certainly there are challenges. We acknowledge that. Would you kind of speak to what's normal in the process, Randolph?
Sure. So each jurisdiction is different, and it depends on how the sheriff's department or the department that controls the jail and does the transport deals with each inmate. Some departments would rather have the attorney bring the clothing or the family member bring the clothing to the jail, allow the defendant to get dressed at the jail, and then transport them that morning in the clothing. Some jurisdictions, the sheriff's department, rather the lawyer bring the clothing. And obviously all this stuff has to be searched, right? Because they don't want things from the family maybe being snuck in. So that there are security concerns that they have about checking the clothing, make sure that there wasn't something put in there by a family member. So it is a lot for the sheriff's department or whichever the police department that's handling that transport to deal with this every single day. It is doable, but it's a lot of work to add on top of. Remember, she's not the only one in that courthouse that day. They're bringing other inmates over. So it's not the Sarah Boone show. It is the sheriff's department having to bring multiple people and she's probably gumming up the works with all of her requests.
Oh, you're so right, Randolph. You're so right. Can you imagine her in the transport van? Because, that's the way it goes for our wonderful courties. There's a big van that goes from the jail, multiple trips sometimes, and you have multiple prisoners in it. As Randolph noted, it's not the Sarah Boone show, although she'd like to make it the Sarah Boone show. I wonder what those other inmates think about her, what they're saying about having to spend that time in the van with her and hear about these crazy requests. Oh my gosh, I bet they have stories to tell. I have another clip I'd like to play for you, Randolph, and this is where her attorney, if you recall the other day, the judge was asking about the defense witness list, and Sarah Boone threw her excellent counsel right under the bus and said, I haven't seen the list and I'm not agreeing to it because I don't know what's on it, and really made it seem like they haven't communicated. And we know James Owens is a very seasoned attorney and has communicated with her. And so here, fast forward to the other day, she finally agrees as to who is on the witness list. Let's watch.
Forgive me, Your Honor. Could you please repeat the question?
Sure. The question was, without going to any specifics about conversations that you've had with you and your attorneys, are you in agreement with the persons that have been identified in that list that may be called as witnesses in your case?
I'm not familiar with everyone that's on here, but I do agree with whoever it is that they have on here.
Okay.
Ooh, okay. Randolph, she's, what do I want to say? What's the expression? Dumb like a fox, right? She kind of played a little dumb there about, well, I don't know who's on the list, but I guess I agree. Do you think she's trying to set up some kind of post-conviction relief for herself or ineffective assistance with some of these comments she makes?
I certainly think she is. She is probably trying to lay the groundwork for either a appeal or some sort of complaint against her attorney saying that they didn't provide me this information. I never got to look at it. And that could certainly be a basis for an appellate court to look at this case and say, well, you know what, we need to give her a new trial. She's being very sly. Again, this is the Sarah Boone show. She thinks she's smarter than everybody else. And so I certainly think she's being cryptic. I think she's maybe trying to be a little difficult, which, look, she's going to be difficult through this whole trial. There is no doubt about that. So, with the food request and the clothing request, and by the way, Julie, do you have any more Pop-Tarts? Could you send some to me, please?
Yes, Randolph, absolutely. You deserve all the Pop-Tarts. You're one of our favorite legal analysts. And gosh, I know, I wish I could, send some through the television to you right now. Yeah, we should get snacks, right? We don't snack, we do our jobs. That's what we do. My goodness. Randolph, do you think the judge, before we hit a break, do you think this judge is going to grant this request? Because at the end of the day, it's in his hands, as you know. What do you think?
No, this judge seems to be a no-nonsense kind of judge. He's going to call it right down the middle. Remember, judges are there to call balls and strikes, and they're going to take the law, they're going to take the current rules that have been set up by the courts, and they're going to say, look, I'm looking at what you've presented to me. I'm going to look at the facts. I'm going to look at the law and what the courts have said, and I'm going to make a call here. I'm going to make a balls and strike decision here, and we're going to make it reasonable. And so I think he's going to make reasonable calls, but I don't think he's going to put up with her shenanigans as this trial proceeds.
Right. And we know she doesn't have a medical issue of low blood sugar and doesn't have a need to have candy or juices there at the desk. And the jury's not getting it, right? The jury's not getting snacks to munch on. So why should she?
Hey, Julie, 2 hots and a cot. That's what we always say, and that's what you get, Trust me, the sheriff's department is providing plenty of food. It sounds like she's getting a peanut butter and jelly sandwich, and it sounds like she's even getting cookies. I don't even get cookies during my lunch, so she's doing better than we are.
We got to talk to somebody about that. We got to get some cookies for Randolph Rice and some Pop-Tarts. You're the best, Randolph. Stand by kindly, if you would, please. We're going to hit our first break of the hour right now, friends.
The drama continues in the case of Sarah Boone, the accused killer who prosecutors say zipped up her boyfriend in a suitcase while playing hide and seek and left him for dead. It's now been 4 years since then, and Sarah Boone is finally set to go to trial next month.
Oh, movement. Here she comes, guys.
Her case with the most shocking moments we've seen so far and what to expect ahead. Welcome to Sidebar, presented by Law and Crime. I'm Sarah Gillespie.
Here she comes.
The drama just
Gross. Which one is it? It's that one. We are in the courtroom. Woohoo! Oh, she's not looking a bit pucker this morning. She's looking a bit like she's had no sleep. They're twinning today again. Oh, I wonder who she's talking to behind her. Who do we think it is, guys? Who do we think it is? Oh, it's one of her attorneys. They're definitely twinning this pair. Look, their suit jackets are identically the same colour. Wonder if she's done that so she looks like she's a lawyer. Can I have my snack, please? Oh, she's loving this, guys. And it's weird because the other two are twinning in blue.
William J. for the state.
Fix the mic, Judge.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk has advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come?
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you. State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay. Correct. That's correct. Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you?
Woohoo!
Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
Come on, Sarah,
Ms.
smile.
Reynolds?
There's a little bit of a delay for you, darling. She does look tired.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir.
I've got to entertain
sir.
you for 15 minutes.
Yes.
I think. Hang on.
You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Well. So we've got 15 minutes to kill. What a lot of faffing around. But I like the fact that the prosecutor is like, we need to press on. We need to crack on, not waste this jury's time. Let's get on with this. So yeah, we'll see how that goes. What have we got that we can watch for 15 minutes while we're? Cause I don't think I can talk about it for 15 minutes, because there's just so much to cover and so much to talk about. What else have we got in here? What else have we got in here? Bugger. But at least they're trying to use the time wisely. Going to be up and down like a yo-yo, wouldn't we? There was something I was looking for the other day that I didn't really find. I wanted to find. Oh, I know what we can do. Shall I look at Sarah Boone's letters? Sarah Boone. Sarah Boone. Oh, why is everyone so fucking loud? Why are they all so loud? There's not one angelic person, I tell you, in our household. They are so loud. I'm angelic, of course. I wouldn't make such racket. Because I am angelic. So let's go to... Oh. So. This is the county records search. It is open. And this is all her dockets and files and forms and stuff. Evidence control sheet. What is that? Oh, the only problem when I open it up, guys, is that I'm going to have to... CD, DVD. Okay. I have to change the bloody screen because it takes me to a different page and I don't think you guys can see it. But at the moment, as you can see, these are all like the state's response, orders, hearing trial date set, witness list, notice of supplemental discovery. So this is where all of the documents and everything that needs to go in here. Now these green ones are public. Any that's in orange is not public. And VOR is on request, which most of these, I don't think there's any actually that I can see. That are viewable on request. Because obviously now I've done my first FOIA request and actually got the stuff. I want to see what happens. But I want to find the letters for you guys. Hang on. Notice of filing intent, motion of cost, notice of appearance, court minutes, filing, appearance, defense, motion, filing, certificate, petition, affidavit costs. All these things that don't cost Sarah Boone a damn penny. Ooh. Sealed document. I wonder if that will come out after we have a sealed document. Correspondence from the defendant to the judge. Okay, let's open up these. I am going to have to... I still haven't bought a mouse pad, and I'm going to do it in a minute when I'm on here. Feels like... Hey, Queenie, they've just... they've just gone to do something, and they need 15 minutes. And it wasn't actually Sarah Boone's side. Let's just... let's see if I can... Ah, there it is. There it is. There it is. There it is. Oof, oof. So there you go, guys. You can see the letter there, right? I'm not going to be able to see the comments, but because I need to obviously be on this bit so I can read the document to you. It's bloody ridiculous. See, the mouse pad, the mouse mat just doesn't come as a list of my priorities. And so like I'm like, yeah, I'm going to sort it out. I'm sorting it, and then I just never do it. So she's got some sort of handwriting going on there. Part of me thinks it's kind of neat, and then another part of me is like, I can't fucking read some of it. So if it's not readable, it can't be that neat, can it? So she's put in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida. The state of Florida, plaintiff, Sarah Boone, defendant. Motion for defendant's immediate address correction. Comes now, Sarah Boone, pro se. Indigent defendants respectfully request from the court to change and update the correct defendant's delivery mailing address immediately. Surprised she didn't capitalise on that. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel by the court and then forced to become pro se and now does not. The incorrect address was not provided to the court by the defendant nor requested ever to be changed. All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real, I think that says. Wait, how do I flick through this? Right, no. I don't want page 5. I want the next page. Wait, oh, hang on. Okay, it's a scrolly job. It's a scrolly job. In real time response. So she wants it in real time. The proper notice and preparation of any requirement contained therein. See, I told you this household is noisy. This is all down. Let me see if we can hear this noise. Honestly. She won't do it now. You wait. Let's put the headphones in. The defendant is requesting the court to please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, and all this the defendant may be attached to by the court. Please also provide all the necessary documents for official record of address change to be filed accordingly by and in the court. I feel like she's got like a Google thing and just copied it and then put in the relevant bits that apply to her. By this motion, the defendant is expecting no further hindrance, difficulties, deterrence in the court's fair and proper correspondence to be delivered to the defendant at the following address. Legal Mail, Sarah Boone. # 20005623//FDC-B4 PO Box 4970. So we can all write Sarah Boone a letter and see how she's doing. Perhaps maybe after the trial, I might drop her a little letter and just say, hey, I'm not a fan, but I just wanted to let you know I watched the trial, and whatever the outcome is, whatever my opinion is, I'll include that. We can't be friends. Like, I'm not one of your fans. I'm not a friend. I just felt that I needed to drop you a letter, but I'm not going to do that before the trial's over. Please be advised also that, can you imagine if she mailed me back? I'd about die. Please be advised also that the defendant mailed by UPS this information for formal letter to the court on August the 1st, 2024. Pen pals, yeah. Oh, yeah, we could send her some snacks and some treats to see her through, couldn't we? She'll go another day. There's no, well, they're looking to go through it, Witch Hunter. I think what's going to happen is they're going to try and push through and start opening today. It's just, obviously there's this glitch here that they need to deal with, whatever this is the prosecution wants to confirm, for his reasons to confirm everything. And then he wants to power on. He doesn't want to waste any more of the jury's time. He wants to get on and push on till 5 o'clock. Can you imagine when it comes to verdict watch? Because sometimes the judge will allow verdict watch to go on till 8 in the evening, especially if they think it's a clear cut, like this ain't going to take long. Because then Sarah Boone won't be getting to her bed till about 1 in the morning. Where are they actually keeping this woman? I'm not gonna lie, where are they keeping her? Because I'm concerned that they're keeping her in places that's way too far away. Which, if it is, I'm just gonna say, hey, Boone, I know we're pen pals now, but I do think it was out of order that you were woken at 2 a.m. Especially when you didn't get in till 9 p.m. What the hell? Where the hell? Wonder if we can. Yeah, we could. Well, we actually probably wouldn't be able to send her the treats, Donna. We'd probably have to send the money to the commissary. But we know she likes Pop-Tarts, so anyway, so obviously the formal letter by the court was on August the 1st, 2024, to emphasize the importance of this immediate correction to be made on the court's behalf and from the court's error. Wherefore, Sarah Boone I mean, you could probably knit her something. Like, I mean, I know when Letitia Stalk, she said in one of her prison calls that she's allowed a box a year where they can have anything in them. I've never eaten a Pop-Tart. I feel like I need to eat a Pop-Tart now, but I've never had the desire to eat a Pop-Tart. Maybe I could eat headbands for her hair. Makeup. We get some makeup. Get Sarah Boone her makeup. She'll be well happy with that, wouldn't she? I used to have them as a child. See, I wasn't allowed them as a child. Like, I want you. We were talking about this the other day, me and Mrs. AD. You know the bubble bath. They look like them little. What do you call them? Them dolls that live in dolls that go in the dolls. Those bubble bath, matey bubble bath, right? I always wanted the matey bubble bath, but I wasn't allowed them. My mum wouldn't let me have them. There was not an option. I was told it was far, far, far too expensive. I also wanted horse riding lessons. This is where is me now. Now you've started me. I wanted horse riding lessons once. My mum's like, yeah, I'm going to go looking into that. Don't worry. We'll look into that. And anyway, so I hounded the hell because I always wanted my own horse and always wanted to have lessons. And I came home from school and I was like, did you find out about the horse riding lessons? You know, because obviously they were expensive. And she's like, yeah, they don't let the horses out in the winter. And like a twat, I believed her. And then I never got my horse, and she never got my riding lessons. I did have riding lessons probably for about a year before I had my last son. Bloody loved it. But my horse riding days were short-lived because then I had my son, and obviously now I'm just like someone that will break into a million pieces. So yeah, so that was my childhood. Wasn't allowed matey bubble bath. The horses weren't allowed out in the winter, and yeah, I didn't do any clubs or anything, and I was a latchkey kid. But it's okay because I'm normal. There's nothing wrong with me. Anyway, so on the bottom of this, she's put oath, and she's capitalised it the whole way through. Under the authority of Section 92525 FL Florida statute, basically, and the state versus Shearer. Hey, it's not Shearer, my Shearer, is it? The defendant makes the following oath under the penalties of perjury. It could actually be a mum or a dad, couldn't it? Judge Share. That I have read and foregoing document and the facts and the matters stated are true. See, I think she'd make a good, should represent herself quite well. I think she's done well. She's got all the legal jargon. We settled for Avon. See, weren't even allowed Avon. My mum has it all now, all the Avon and everything. My mum's got more bubble bath, but I mean, you know, back in the day, things were hard, weren't they? Things are hard. Well, I suppose it's hard now. It's hard now. But we do our best. I've got Adeline snoring behind me, but I'm hoping this mic's drowning her out, so I can't hear her through the headset. Let's scroll up with this letter. But she's using all the right language. I reckon she could have done all right, you know. I mean, obviously, it's better to have a lawyer, obviously. But when push came to shove, I think she could have done it. I think she could have done it. Certificate of service. I hereby certify that the original of this document has been hand-delivered to the Court of the 9th Judicial Circuit on this 5th day of August 2024. See, now me, I'd have just written, "Hi, Judge. The original of this document has been hand-delivered to you at the courthouse." That would have been... But she's proper written everything out fully. She has a copy of this original document, and that can be made and e-served via the Florida Court's e-filing portal system to all the attorneys and the other parties on court record. And then she signs it, puts her address in there and the court's address. So I think she could have done all right, actually. I think if we'd have been... Oh, that's just the envelope. I think if we'd have been waiting for a Daryl Brooks moment, I think we probably wouldn't have got it, because I think she would have been relatively sensible. But I do feel that she should have took a plea deal. It's not what any of us would have wanted, because we've waited a long time for it. But for her, I think it would have been better. So, August the 1st, 2024, Judge Michael S. Kranick, 45 North Orange Avenue, Orlando, Florida. Sarah Boone, case 2020, CF 002603-AO. I thought I just read this one. Have I just read this one? I have just read this. Oh my god. Oh no, this is a different one. Oh, this is the fourth. She's capitalized this one. I was going to say I definitely didn't, because this is only 2 pages. So she's capitalised it on there. So that must be the e-copy. Right, that's only 2 pages. What is this one? No, it's the judge. He doesn't write back, does he? Oh, this is her reasonable movement freedom. Avon was posh. Avon is quite posh. Superdrug wasn't posh, but I think Superdrug's probably quite posh now when it comes to it. So in the circuit of the court, the 9th Judicial Circuit in and for Orange County, Florida. All the details. Sarah Boone, defendant. Motion for the defendant's reasonable freedom of movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilising the courtroom. Now, obviously, I think this was when she was representing herself, so she would be looking to be equal to the other attorneys in the room. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court to be unshackled, unhandcuffed. See, she doesn't capitalise it here, but she did capitalise it at the top there. To be movement in function accordingly, equally and comfortably while utilising the courtroom. You've written that twice now. The defendant must be able to write, reach, turn pages, pick up objects, including snacks, open documents, pass information, utilise the laptop, and all normal movements of the defendant's hands and as a whole to freely, properly, and successfully. And that's true. In most cases, you get to wear civvies and your hands aren't handcuffs. I mean, if you're dangerous, which, I mean, let's face it, I don't think she is dangerous, as in, like, she's not going to do a Taylor business and go and attack the prosecution or the judge. And even if she tried, that's what the ankle shackles would be for. But her hands should absolutely be free. And that's why they have either the curtains around the table, or the tables are blocked so that you can't see the defendant's feet if they are shackled, and it's just so that the jurors can't see that she is an inmate. But the thing is, I think in most of these cases, it's going to be presumed that she is an inmate, but it is what it is. Anyway, she wants her hands free for any task that she needs. Are we back yet? Are we back yet? Oh, we are back in the courtroom. Let's switch tabs. I can carry on reading that, but I don't want you to. There we go, guys. We are back in the room. I will.
Okay. Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay. Thank you very much. Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered.
I'm actually surprised you
All right, the
didn't
court's had the
say,
opportunity to
well,
review
not
the
amenable,
excerpts
because,
from the motion in limine
you know,
hearing from yesterday.
delays
My
it another
understanding is
10
both the
minutes.
state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir. Bless you.
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it. Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines
Hey, Nikki.
22
Yes,
through
she's had 4 years.
24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760.
Yeah, Far and Away
opinion,
Perfume
a
was
Florida
nice.
Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111, Florida 5th DCA, 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA, 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony or trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 Southern 2nd, 750 at pinpoint 760 through 761. beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted. Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that I beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point for the record for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Yes. Just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or die nor
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because
Okay.
this morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time. The 81 pages are not at issue. And what do the 119 pages evidence?
They're medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it was cooperative. Her testimony that she suffered an injury at the hands of George Torres.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the...
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary, we have to take a break and let me find out from my secretary.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3, is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the DAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that right now.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities asking for records, and we're just waiting on response.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 223:20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And
That was a bit brave of him to say that it'd be
struggle to see
boring,
relevance, Judge.
Thank you.
especially where it
Response?
referred to mental health.
Judge, it's similar to the state about 10 days ago.
Oh, I don't know, Donna.
We addressed
Maybe.
that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, but the anxiety she may be suffering.
Defense is pissed off.
So there are questions about that, but
Boone is pissed off.
when you have a forensic psychologist trying to evaluate
I feel
What
like
is the relevance of these records?
the mic is the wrong way
What do COVID
round.
tests have to do with
Turn it
anything in this
around.
case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition.
I can't actually believe I'm going to take Sarah Boone on holiday with me.
This is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course experts can rely on inadmissible evidence if within the course of that area of expertise. It's the type of
Sarah
evidence
Boone
that
and
is
some
provided.
cocktails.
But how are these records relied upon if
That's my
they
week
acquired them
sorted.
after we've done all the
I'm not
depositions?
moving
Now,
from
Dr.
my
Harper did
my
say that she
lounger.
relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not
I will
their
definitely
experts have
need a break
provided these new
before the
records so
next
that we can address that.
run for the next
Sure.
1,000 for sure.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we don't think about the deposition. So I'll wait, I will not ask her to review.
Okay. State with,
That was the only purpose.
okay. So state understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts. Does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know we had some priors in Pennsylvania, Massachusetts, we're not referring to those. We're only referring to the ones involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent? Can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
She's going to testify to it, and then
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up and handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, Dr. Brennan will testify, Dr. Crump will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. That his family can't help her, she has in the group. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Wood says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in the court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one. Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution
may have been filed that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, he testified for the defense, and he may be considered an adverse witness or hostile witness, so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on.
Hi, Karen.
What does the non-payment of alimony have to do with what's happening in a family case?
Well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for, supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order, that shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case and I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Well, so we're going down the he hasn't paid alimony. I mean, I don't understand why she would want him to chase him for alimony, because it's only probably going to go against her court fees, whatever it is, the restitution afterwards. I mean, maybe she wants him to pay the restitution, but I mean, do you pay alimony still when the woman or whoever is in prison? Does that still happen? Because I'm pretty sure if they remarry, doesn't the alimony stop? I mean, I know she's not remarried, and I know she is in the county jail. I mean, she was heavily reliant on him. In fact, I think those documents are in the court. Hang on. Yeah. I know. That's an old. Oh, there it is. Oh. Whoa, no thank you. No thank you. They're all non-public. All of the documents. I wonder if they... Oh, it might be. Confidential parenting class certificate, property settlement, parenting plan, answer waiver, financial affidavit, parenting class certificate, copy of copies, memorandum, final judgment, deduction exhibits, court minutes, evidence control sheet, certificate of delinquency record. So I'm going to say that that's probably the kid not going to school. Change of address. Hearing motion, Dean Michael. Notice of change of address, cancellation of hearing, order granting, motion for contempt, motion for continuance, order for continuance granted, letter, notice, satisfaction of judgment, notice of unavailability, returned mail, motion to window. Jeez. Order denying something was in May. Council withdrawal was in November last year. So that's all been going on in the old background there then. She does. I wonder if she's had a professional. I can't see how he can be expected to pay her alimony. She's not at home. She doesn't have the kid. See how, like, obviously, like when you see what we've seen with the attack, with obviously the suitcase and everything, how can you sit there and laugh with her? I get that defense attorneys have got to do their jobs, right? But there's doing your jobs, and then there's like being best friends. I mean, she's definitely had this trial delayed as as any other. Never known anything like it in my life.
All right, thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection. State any response.
Any and all exhibits previously listed by the state?
Mm-hmm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell.
Okay,
We don't
Donna.
know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there, the rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because
Well,
I can't testify to what she said. The two prosecutors.
that's the first time I've heard him. Heard she whacked him with the bat.
Testify to what she said is Dr. Werner and Sarah Boone.
Wow.
We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not. We may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. She does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
He didn't actually say how long he was going to be, did he? Let's have a little wonder. Let's have a little look. Let's have a little look. Right, let's have a look, see what there is to fill the gap. Because we don't know how long she's going to be. Could be. She's in the courtroom. Let's just watch some more footage.
All right, the hurricane forming named Milton has pushed the Sarah Boone case. The judge just announcing it a few moments ago that jury selection process, which was going to be starting this morning, has been pushed until next week. Let's watch the judge.
Thank you so much for letting me know your positions. As we just discussed, as of 10:46 this morning, the chief judge has decided to close all courthouses due to Hurricane Milton, both Wednesday, October 9th and Thursday, October 10. The court anticipates that operations will return to normal on Friday, October 11th, but that's due to the court's continued close monitoring of the impacts of the storm. Due to the potential storm and the ramifications of it, the court is going to postpone jury selection in this matter till Monday, October 14th at 9 a.m. Mr. Owens, please provide the court the order with regard to the clothing and shoes, and we'll address that as necessary. As also requested, please provide my judicial assistant your cellular telephone numbers before you leave today. With that, the court is in recess, and we will see you all on Monday, October 14th. Thank you. Ms. Boone will be returned to the custody of the Orange County Jail pending jury selection. We're off the record. Thank you.
All right, there it is. Sarah Boone was supposed to sit and watch jury selection take place today. Now, earlier this morning, she had a chance to take a deal. The state announced in open court that they were ready to give her a deal of 15 years if she pled guilty for the lesser charge of manslaughter. Right now, she's facing a second-degree murder conviction, which has a minimum of 22 years. Here is that moment where Sarah says no.
Do you understand that if we were to proceed to trial in this matter, and if you were found guilty, the lowest permissible sentence that the court could levy in this case would be 22.5 years in the Department of Corrections? Do you understand that? Do you understand the state's offer to resolve this case? Okay.
The offer is 15 years to a lesser included charge of manslaughter, with the understanding that she would serve 85% of that sentence.
That's up to the department and her behavior, but that is my understanding.
Ma'am, understanding the state's offer, do you wish to accept or reject the state's offer to resolve this case?
Reject.
Oh, man, she rejected that offer. That's 8. You heard there. It was 15, but she would serve 8. And she's already done, I believe, 4 in jail, go ripping through these 9 attorneys. She's 4 years away from getting out if she accepted that deal. And she said no. Oh, Deputy Public Defender in Los Angeles County, Philip Dubay, is here. He's been sitting next to clients for decades, listening to their offers and rejections and this. Where does this stand? I mean, this to me seems like a no-brainer. Take it, take it, take it.
Suitcase Sarah is a classic example of why we have a job. Okay, Ted, listen, she's the type of client where you need to double team her, meaning you bring in at least 2 lawyers from your firm or your office to sit her down and tell her to knock off the cock and bull and take the deal. Because when she gets out, she'll be 56. She'll have a whole life ahead of her. You know, she's already been in for 56 months. I believe she got arrested on this in February of 2020. So she'll still be a relatively young woman. Worse yet, when you do the legal analysis, I think the best she can hope for from the jury is a manslaughter. They define it as follows. All they have to do is prove that she committed an act, not in self-defense, that caused death. That's it. All they have to do is hit the play button and show the jury that video of him struggling for breath in that suitcase. And they've basically proven the, of manslaughter beyond a reasonable doubt. So what does that get her? The 15 years that they're offering now. Homegirl needs to take the deal and shut up and go do her time.
Yeah, because the chances of a second, while obviously the state is a little bit worried about their case because it is complex. That video, she's not only listening to him, she's taunting him. And there's only 6 jurors that are going to be deliberating in the state of Florida. It's not a 12-person jury. You could just feel this thing going south very quickly, especially if, like they've articulated, their defense is going to be battered spouse syndrome.
Yeah, the only way out of this is to prove some form of self-defense. Because again, they have to prove she committed an act that caused death that was not excusable, meaning it was not in self-defense. And if they think that a battered woman syndrome expert is going to save the day, it's very risky. I would rather take my 15 with all the credit I've got in and be out at age 56 rather than risk life in prison. But she's willing to roll the dice. It's really unfortunate. And this is, again, a classic example of why a few attorneys need to sit her down and explain the risk. And then you can note your files, say she's been advised, and if she goes down on it, she has nobody to blame but herself.
And now it makes sense that she's gone through all these attorneys. We had sort of speculated that the state maybe was offering and she was rejecting, and this, and I think that the state was very eager to get this out on the record and into the public forum. Well, the Hurricane Milton storming towards, or basically Orlando, and it'll drop in intensity by the time it gets inland into Orlando. The court was expecting Wednesday and Thursday to have the courthouse closed. This move, though, to stop the jury selection process on Monday and restart it next Monday, I guess that is to eliminate the possibility that you pick a juror, their house is leveled, and they can't serve.
Of course, yeah. I mean, we're fortunate out here where I live. We don't have to worry about having to batten down the hatches whenever it rains or you get a windstorm, you know. But unfortunately, most of the country is not like that. And to be fair, nobody really knows where the jurors live or the jury pool. It could be possible that even though the courthouse is inland, that they live closer to the ocean and they need to get home and board up their windows, make arrangements for their pets, pack things up, put sandbags out and get ready rather than sit serving their civic duty as a juror, you know. So, and by the way, the players in the justice system likewise need to get home and take care of business. The judge, the court reporter, the clerk, a counsel, you know, they all have obligations at home that they've got to contend with to avoid tragic type destruction from what appears now to be a Category 3 or a Category 5 hurricane. You got to deal with it.
Yeah, absolutely. It was a prudent decision for sure.
The problem is I fell asleep. I fell asleep. When did you do CPR? This morning, when I found it. Before you called? Yes. 1 o'clock right now. Good, Aaron. I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, oh, he's in the suitcase still.
The body camera video of Sarah Boone, if you look closely, you see the date of that. This is, the morning that 911 is called and Orange County Sheriff's respond. It was 2/24/2020. Now, finally, Monday, attorney number 9 will be representing her, and the trial will begin right here on Court TV. Now, we've got an update because Sarah Boone made some motions, pretrial motions with her new attorney prior to the beginning of this trial. Let's go through some of them. First, she had a request to have her hair done. And yes, that's a check. Yes, you can have your hair done, Sarah Boone, at trial. Request to wear civilian clothes. Check. You will get to wear your civilian clothes. Okay, request to have her makeup done. Not happening. They had to draw the line somewhere. It seems like corrections had a little problem with that. Can't have it done. So she'll have her hair done, but she's not going to have the professional makeup artist come in. Request to have shackles and restraints removed during the trial. Yes, that would be prejudicial. And finally, this is the big one, folks. Request to have her interrogation video suppressed, kept out of evidence. It's coming in. It is coming in, folks. The interrogation video where she makes a lot of statements. She's all over the place. And in statements that may be considered inconsistent with the defense in this case. So Sarah Boone was on the stand on Wednesday for this pretrial motion here, discussing her mindset going into the police interrogation that she wanted tossed out of the case.
I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Well, the one thing, I mean, this is the first time I've seen her speak, and she seems relatively, like normal, right? She doesn't seem like something's off there, which may help her at trial. I took that away, but the explanation the judge wasn't necessarily buying as a basis to suppress it, so it's coming in. So I want to play for you some moments from that interrogation that the prosecution may want to use and the defense may not want the jury to consider.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. I don't know, what you want me to tell you.
I'm just showing you. I'm just telling you what we see and what we've heard from the other video.
I understand.
He's begging for you to let him out. You're laughing in the beginning, and then in the end, it sounds kind of like
No, it's not malicious.
Well, saying
It's not malicious.
then what is that?
What does mean to you?
Well,
so it goes from funny to no longer funny, but you're the only one laughing.
But I didn't think that he was panicky.
So pushing up on a suitcase saying Sarah, Sarah, Sarah. I can't breathe.
George has done that in the past before too, where it's just he thinks that he's woe is me kind of thing, where it's
He's never been locked in a suitcase. That's why he couldn't get out. So
it's I thought it was crying wolf kind of thing.
Okay.
And again, my plan.
But nowhere in there is he laughing, is he joking. He is begging. And you're the only one laughing.
Okay.
And you're the only one saying derogatory comments, like you're mad.
No. Please don't, I don't mean to sound negative, and I don't know if I can say this, but it's like you guys are kind of trying to feed me.
No, I'm just trying to show you a video that you no longer want to watch because you probably don't want to know the outcome of how and what you said.
Well, I know what.
You know what's on that video now?
No.
You remember making that video?
No.
Why don't you remember making the video? Probably because we had been drinking. But you weren't drunk. No. Just because I went upstairs and just
You
because
told
you're
us-
drunk doesn't
you
mean
told
that
us
you.
times that you were not drunk. You said that you had your wits about you. You said he had his wits about you.
Mhm.
You said that you don't like not having your wits. In my experience, if somebody cannot remember doing something to the extent of making 2 videos and a video and taking a photo, they are intoxicated.
Okay. My plan was not to go upstairs and go to sleep. My plan was not to, he'll be up here any minute.
But you
willingly went upstairs and went to sleep. No one forced you to go upstairs and my plan was also to leave him in the suitcase. So why didn't you take him out? Because I went upstairs and then I fell asleep.
Okay, her defense now is battered spouse syndrome, self-defense. That's where the case is going. That's where the focus of the defense will be. Paulette Lofton, how much of a problem is this 2-hour interrogation, pieces like this? Does it fit with the defense, or does it become a problem for her?
I don't think it fits at all. So I think it's a large problem that those interrogations are going to be played for the jury. It's clear, if we believe the facts as she presents them in those interviews, she at least had the upper hand at some point. She had him in a suitcase. He was unable to get out of the suitcase himself. He's begging her for help, and she took it upon herself to not call the police and tell them, you know, I'm finally done taking him back. This is the abuse I've been suffering. She went upstairs and went to sleep. It's clear that she's also making inconsistent statements, whether she was intoxicated or she wasn't intoxicated. I think that interview is really going to hurt her. I agree with you. I think she did present well in that hearing that they had earlier this week, and she seems to be calm and listen to the questions and answer them appropriately. But I think the jury's probably going to give a lot of weight to those interviews in the first hours after she calls 911.
I agree. Ben, the video is so powerful because you can hear George Torres suffering. Like any human hears what he's saying. You're like, this is a man obviously in distress. And she's not really acknowledging that. She literally said, he's always like, woe is me. George is dead. I mean, he suffered a horrible death. And afterwards she's saying, oh, he's always going, woe is me. That's a bad look.
Yeah, it's horrific. And just even the visual image of the suitcase and imagining somebody in that tiny area, it must have been torture for him. I think I agree with Paulette. I think it's absolutely damning and completely inconsistent with battered spouse syndrome.
So Bernarda, and one thing that the attorney James Owens has said is, and he said it in court, he said it on the show, that I think a lot of focus will be about what happened before he got in the suitcase, and then also what happens before the video camera begins recording. I don't know what it's going to be, but it's got to come from her mouth, right? She has to testify in this. I don't see any way to attempt to make a case without her testifying.
Absolutely. So Sarah Boone does plan to present this defense of battered woman syndrome or self-defense. She's going to have to take the stand. So the big issue for her is, number one, is that she gave prior statements. She has the videotape statement. She has the statement from when the officers first encounter her. So she's going to be confronted with both of those statements and then what story she's going to give while on the stand. So if you look at all three of them, right there, you have a lot of inconsistencies. And when you're trying to evaluate credibility, one of the main factors that you look at is are there any inconsistencies? Has she said this story before? Did she first report it when she had the first opportunity? For example, when the officers first came to her, and they're going to find that she did not. I don't think she comes off also as likable. And also, one thing that does work in her favor, though, Vinny, is that the prosecutors don't have exactly what happened beforehand. The only two people that can say what happened beforehand is Sarah Boone and the person who is dead. And now that person's dead, so they can't speak.
Paulette, the expert really has to, a defense expert has to explain to the jury all of her behavior afterwards, right? That's the only way to try to reconcile it, because I think if regular folks who haven't studied this syndrome and don't know anything about it will just look at her and then listen to George in the suitcase, and we're gonna believe that this whole thing is made up unless an expert can somehow explain why she would be like she was in the video, on the body camera video, and in the interrogation room.
I agree. Battered spouse syndrome is absolutely something that is real and can be proved. So yes, I think this is going to really turn into a battle of the experts. The experts will be able to explain to the jury that her behavior is either common or not common with someone who is actually suffering from the syndrome, and why she may not act like you would think you would act in a similar situation. So it is something that is possible. It is something that is proven to juries. But I think those videos are really going to come back to haunt her. And I think whatever the expert says, I think the jury is going to put a lot of weight in those first interviews that she did.
Big thank you, Paulette Lofton, Bernardo Villalona, Ben Chu. Appreciate it. Have a great weekend. When we come back, I will reveal something else you need to know, plus coming up next hour.
Tonight on Vinnie Politan Investigates, a wife and mother is stabbed to death, and a man responding to a BDSM ad is shot and killed. What is going on in Virginia? Tonight, we investigate.
Okay, I was talking to myself, and that wasn't great, was it? So I've just had a little look round while that was playing. The live stream has now been ended. I can't see it at the moment, so it may well be that they've privated it, and I don't know if it's still going. But because of the jury selection, which won't be in front of cameras, it may be that they've took it off, and then it could come back if they do start off, because I know the guy seemed very keen to get pressing on till 5 o'clock, and he was going to be telling the jury this, that, and the other this afternoon. So for now, I'll end this live, and if anything else then comes up and they start restreaming, I will be back. So for now, we'll end it here. And if we're not back on here later, then yeah, we'll be back on our TikTok, After Dark Coffee and Crime over there, and be catching up on some stuff there. So guys, stay safe, and I will speak to you all very soon. Bye guys. Where is my mouse? Oh my god, my mouse is dead. Dead.